Hi, I'm Patrick Cannon of Cannon Chambers, and I'm a barrister who specialises in property taxation, including stamp duty and stamp duty land tax. I advise on stamp duty on property purchases, and I also represent taxpayers in inquiries and appeals against HMRC in the tax tribunals and the courts. You can check some of my recent tax tribunal cases in the notable cases section of the Cannon Chambers website. This video is about whether or not a property qualifies as an uninhabitable dwelling. And if you are buying such a property or you have bought an uninhabitable dwelling in the last 12 months, it's important to know about this so that you can make sure that you have not paid more stamp duty than necessary. We'll look in detail at the definition of an uninhabitable dwelling in a moment. But it's quite important to make sure that you don't classify the property you are buying as uninhabitable if it is merely badly run down or in need of substantial renovation or repairs. The clue is actually in the term uninhabitable. At the time of purchase, the dwelling must be truly in such a state that you could not inhabit it, and the extent of the repairs needed mean that the building is really only suitable for knocking down. Why is this important? Well, if the building is uninhabitable, then it is classed as non-residential property, which means that the 3% higher rates for additional dwellings and any dwellings bought by companies will not apply. And you can apply the lower rates of stamp duty in what we call Table B, with its top rate of tax on the slice of the purchase price above £250,000 at 5%, instead of the much higher rates of stamp duty for residential property in Table A, with a potential top rate of 17%. Now, you really don't want to claim that a dwelling is uninhabitable where on the facts it is not actually uninhabitable. This is because HMRC review almost all cases where a dwelling is purchased and it is stated in the tax return or in a refund claim that the property is non-residential. HMRC apply a very strict test, and if the building was used as a dwelling in the recent past and remains suitable for use as a dwelling, as long as repairs or renovations are made to it, then HMRC are likely to challenge any claim that the dwelling is uninhabitable. What's more, HMRC operate a very confusing policy of initially accepting claims or of paying out stamp duty refund claims, but then opening a check into such claims towards the end of the 9-month inquiry period following the submission of the SDLT return or the making of the refund claim. And then they ask for repayment of the stamp duty that has been saved or for the refunded amount back if on a review of the property concerned they disagree that the conditions for the dwelling to be uninhabitable were satisfied. In these cases, and subject to any appeal against HMRC's decision, you will have to pay the additional tax to HMRC plus interest, and depending on the facts, a penalty for making a claim that could not be supported on the evidence. If you're thinking of treating your property as uninhabitable for stamp duty, then do take expert advice. And don't just assume that a surveyor's report showing dilapidations and extensive repairs required will be enough to make the dwelling uninhabitable. We'll look more at this in a moment. What is an uninhabitable dwelling? Well, the clue is actually in the term uninhabitable. For example, I advise clients from time to time who are under investigation by HMRC for treating a dwelling as uninhabitable, when the dwelling was actually occupied by the sellers up to completion, or even worse, the purchasers moved into the dwelling and lived there after purchase. In that situation, explaining to HMRC why you claimed it was uninhabitable when you lived there will test even the most persuasive of barristers. What qualifies as an uninhabitable dwelling? Well, recent decisions of the tax tribunals set out what the tax judges think is an uninhabitable dwelling. And as a result of a recent decision called Mudan, the threshold for a building to be regarded for stamp duty as uninhabitable has been set very high indeed. So much so that few, if any, dwellings will ever qualify. You can read the Mudan decision, in which I represented the taxpayer, in my notable cases pages. But in summary, this decision concerned whether a house that was unsafe to occupy at the effective date of the transaction was nevertheless, quotes, suitable for use as a single dwelling, unquotes, and so was liable to the rates for residential property in Table A, and also the additional 3% rates for additional dwellings. The starting point when considering whether a building is uninhabitable is to ask whether it meets the definition of a dwelling in the stamp duty legislation, which is that it counts as a dwelling if it is used or is suitable for use as a dwelling or is in the process of being constructed or adapted for use as such. You can see the relevant quotes from the tribunal's decision in Mudan at paragraphs 53 and 54. If you go to the case in my notable cases pages. But on the basis of this decision, a property with dangerous electrics, which a qualified electrician's report said were a danger to life, and that as a result, the building should not be occupied until the necessary repairs and renovations have been carried out, will still qualify as suitable for use as a dwelling, and so attract the rates of stamp duty in Table A, and it cannot be treated for stamp duty as uninhabitable. Now, some may find that surprising, but currently that is the position. You can therefore see why it is quite difficult for a dwelling to be classed as uninhabitable for stamp duty purposes, and why you and your advisors should consider the evidence very carefully indeed before making a claim to HMRC that a building is uninhabitable. As an aside, what does "in the process of construction or adaptation as a dwelling" actually mean? Well, recent case law tells us that this test requires that the physical process of construction must have begun before the precise moment of completion of the purchase occurs on the date of the land transaction. This means, for example, that the obtaining of planning permission or the digging of boreholes or demolition works will not themselves count as the process of construction. You can read more about this in the leading decisions of the upper tribunal in Ladson Preston and AKA Developments, in which I represented the taxpayers. And you can read this in my notable cases pages. However, normally this will not be relevant to uninhabitable dwellings because, of course, the whole point of construction or adaptation of a dwelling will, of course, be to create a dwelling that can be inhabited. But I mention these points just for completeness. Can you reclaim stamp duty on an uninhabitable property? Yes, you can, if the property you bought was truly uninhabitable and you initially paid the higher residential rates of stamp duty under Table A instead of the lower rates for non-residential property under Table B. Does the condition of the uninhabitable dwelling impact the stamp duty charge? Well, yes, if the condition of the dwelling is so poor that the defects cannot be put right without effectively knocking the building down, then the lower rates for non-residential properties in Table B are likely to apply instead of the higher residential rates in Table A, and the 3% higher rates for additional dwellings. Are there any government schemes or incentives for buyers of uninhabitable properties? Yes, many local councils offer financial help to bring empty or derelict properties back into use as dwellings, or to convert commercial buildings or large dwelling houses into flats, and you should inquire of the local council if this is of interest. Does the time that it will take to deem it habitable affect the taxation treatment? Well, not as such, because the question is really whether at the effective date of the transaction the building was uninhabitable, so that if at that time it remained suitable for use as a dwelling, based on the approach I've discussed from the Mudan case, then the time actually taken to carry out repairs or renovation will not affect the matter. How do you claim for an uninhabitable dwelling? Well, there's no actual claim as such for an uninhabitable dwelling, which means that you don't actually make a claim in the return. Instead, if you believe that you have bought an uninhabitable dwelling, you answer question 1 on the SDLT1 return by indicating that the property is not residential. And for this purpose, you use code 03. And you also submit an SDLT4 return. And then you pay the rates of tax for non-residential properties in Table B. When to get in touch for advice? Well, I hope that what I've said has persuaded you that it is not safe to simply assume that a building that is derelict and in need of substantial repair or renovation must automatically be an uninhabitable dwelling for stamp duty purposes. Despite what some dodgy stamp duty reclaims companies may say on their website, on their Instagram ads, or in their mail shots to you, recent case law has made it much more difficult to meet the test for an uninhabitable dwelling. You need to be very careful and take a realistic view of all the surrounding facts before you decide to pay the lower Table B rates of stamp duty on the purchase of a dwelling. And you don't want to receive the dreaded brown envelope from HMRC informing you that you are now under tax investigation. Feel free to contact me for further advice about this if you're concerned to get your tax right, or if you are under investigation, using the link below. Thanks for watching, and goodbye.